Good day! Welcome to Lawyer Up by NDV Law. This is Atty. Nikki de Vega, Managing Partner of Nicolas and de Vega Law Offices. In today's video, I will talk about the abuse of dominant position in light of competition or antitrust laws. The term abuse of dominant position refers to anti-competitive business practices in which a dominant firm may engage in order to maintain or increase its position in the market. Abuse of dominance or monopolization is punished under competition laws worldwide. In fact, in the US, Section 2 of the Sherman Act penalizes a person who shall monopolize or attempt to monopolize or combine or conspire with any other person to monopolize any part of trade or commerce. On the other hand, Article 102 of the Treaty on the Functioning of the European Union, or the EU, punishes any abuse by one or more undertakings of a dominant position within the internal market or in a substantial part consisting of imposing unfair prices and trading conditions, limiting production, applying dissimilar conditions to equivalent transactions, and conclusion of contracts subjecting acceptance to supplementary obligations to the prejudice of consumers. In the Philippines, abuse of dominant position is punishable under Section 15 of Republic Act Number 10667 or the Philippine Competition Act. Specifically, Section 15 prohibits one or more entities to abuse their dominant position by engaging in conduct that would substantially prevent, restrict, or lessen competition, such as 1. Selling goods or services below cost with the object of driving competition out of the relevant market. 2. Imposing barriers to entry or committing acts that prevent competitors from growing within the market in an anti-competitive manner, except those that develop in the market as a result or arising from a superior product or process, business acumen, or legal rights or laws. 3rd, making a transaction subject to acceptance by the other parties of other obligations which, by their nature or according to commercial usage, have no connection with the transaction. 4, setting prices or other terms or conditions that discriminate unreasonably between customers or sellers of the same goods or services, where such customers or sellers are contemporaneously trading on similar terms and conditions, and where the effect may be to lessen competition substantially. 5, imposing restrictions on the lease or contract for sale or trade of goods or services concerning where, to whom, or in what form goods or services may be sold or traded, such as fixing prices, giving preferential discounts or rebate upon such price, or imposing conditions not to deal with competing entities, where the object or effect of the restriction is again to prevent, restrict, or lessen competition substantially. 6, making supply of particular goods or services dependent upon the purchase of other goods or services from the supplier, which have no direct connection with the main goods or services to be supplied. 7, directly or indirectly imposing unfairly low purchase prices for the goods or services of, among others, marginalized agricultural producers, fisher folk, micro, small, medium enterprises, and other marginalized service providers and producers. So those are not included there. 8, directly or indirectly imposing unfair purchase or selling price on their competitors, customers, suppliers, or consumers. 9, limiting production, markets, or technical development to the prejudice of consumers. Well, as can be gleaned from the enumeration, predatory pricing, imposing barriers to entry, restricting or refusal to deal, price discrimination, and exploitative conduct that would substantially prevent, restrict, or lessen competition exercised by entities in a dominant position are prohibited. However, not all acts are punishable. In fact, under Section 15 of the Philippine Competition Act, it enumerated that the following acts are not considered as abuse of dominant position. Number 1, acts whereby the dominant entities have no object of driving out competitors out of the market, and the price established was in good faith to meet or compete with the lower price of a competitor in the same market, selling the same or comparable product or service of like quality, as determined by the Philippine Competition Commission. Number 2, barriers to entry as a result of or arising from a superior product or process, business acumen, or legal rights or laws of the dominant entity. So if you achieved it in your own right, you're exempted from liability. Number 3, permissible price differentials, such as socialized pricing for the less fortunate sector of the economy and those that reflect actual differences in the cost of manufacture, sale, or delivery resulting from differing methods, technical conditions, or quantities in which the goods or services are sold or delivered to the buyers or sellers. Those offered in response to the competitive price of payments, services, or changes in the facilities furnished by a competitor, and of course those made in response to changing market conditions like marketability of goods or services or volume. Also, you're not liable in cases of permissible franchising, licensing, exclusive merchandising, or exclusive distributorship agreements, such as those which give each party the right to unilaterally terminate the agreement. Also, though you're not liable for agreements protecting intellectual property rights, confidential information, or trade secrets, and a general catch-all fishnet, any conduct which contributes to improving production or distribution of goods or services within the relevant market, or promoting technical and economic progress while allowing consumers a fair share of the resulting benefit. Determining whether a firm has a dominant position is done with reference to a defined market. That is, the firm has a dominant position or is a monopoly or has power with respect to a certain product and geographic market. Thus, it is pertinent to look at the company's share in the relevant market, barriers to entry, power of competitors, access of competitors to inputs, countervailing power of consumers, among others. The law, PCA, also states that there is a rebuttable presumption of market dominant position if the market share of an entity in the relevant market is at least 50%. So it bears great emphasis that the mere possession of a dominant position is not prohibited. It is the act of abusing such dominant position that is punishable. Under Section 29 of the Philippine Competition Act, abuse of dominant position is punishable by administrative fines of up to 100 million pesos for the first offense and up to 250 million pesos for the second offense. Wow, that's a lot of money for fines. Well, if this video has been helpful, kindly subscribe to our YouTube channel by clicking on the subscribe button. You can also visit our website, ndvlaw.com, to learn more about legal matters in the Philippines. Again, this is Atty. Nikki de Vega, Managing Partner of Nicolas and de Vega Law Offices. And thank you for watching Lawyer Up by NDV Law.